Welcome to You Can't Say That in Court, a podcast by Rise Women's Legal Center. I'm Vicky Law.
And I'm Stephanie Melnick. We are your hosts in this conversation about survivors of violence navigating the BC family law system. We recognize that this system is colonial and causes harm to families, and that disproportionately impacts Indigenous people.
By speaking more widely about these harms, we hope to raise awareness about the challenges that survivors face as they navigate the colonial family law system. This podcast is our attempt to collectively identify the barriers and ask for positive changes to be made. Thank you for joining us. Our podcast series will discuss difficult topics such as gender-based violence and intimate partner violence, including physical, sexual, emotional, psychological, and financial abuse. Please be aware that this is a thread that is woven throughout all the episodes, and we hope that you will take care of yourselves however you need. Hi, everyone. Thanks for joining on episode 8 of You Can't Say That in Court. Today, Stephanie and I are going to talk about litigation abuse and how it presents as family violence when parties are going to court. Litigation abuse has many names. It can be called litigation harassment, court-related harassment, and I think another word might be paper stalking. I think Stephanie, you taught me that.
I learned that from Haley. Yeah.
Yes.
Yeah, paper stalking.
Well, maybe Haley taught me that too.
Right.
And I thought it was you. But there are very many names for this, and it's sometimes, again, with all the other forms of abuse that we've been talking about, difficult to explain. And it is where a perpetrator of abuse is using the legal process to try and maintain control over the other person. And it's hard to detect because sometimes these are very legitimate legal processes that someone is entitled to pursue. But some of the examples, and we'll get into in depth more of various ones, but some of the examples that it could appear is like filing court applications in many different court locations, using multiple legal systems against survivors. So that could be the criminal, the immigration, and what we call family policing or the child protection system against survivors. And we're going to get into the specifics of that intersection in future episodes. So we're not going to touch on that right now, but it is interesting. And there's a lot of nuances on how that can be used against survivors. Yeah,
for sure. Yeah, I pick up on the words you said, the legitimate legal processes, because there are so many different options for people to make applications in the family court context. And over time, it kind of occurred to me that I mean, it's not like a big revelation. Lots of people understand this, but just that the court system is designed inherently to try and be neutral. And that leaves it open for exploitation by someone who is being abusive, because the courts are meant to only rely on evidence and make judgments once they've heard all of the evidence and all of the applications, everything that's being submitted. And so there's this basic assumption that everyone is coming to court on equal footing, that everyone's there to try and find a resolution, that people maybe have good intentions, and that they are trying to actually work through things. And that assumption can just get flipped by someone who wants to slow down the process or wants to cause problems for the other party, because the courts don't know how to react. It's not how they're designed. So this inherent neutrality in the court system is ripe for exploitation by someone who doesn't want to play by the rules, or with all the examples you're giving, like using multiple court locations, filing multiple orders, and all of that stuff requires an answer from the opposing party. And it's just a really insidious way to force someone into that power imbalance again.
Mm-hmm. And I think one of the ways, like, for example, filing in different court locations, someone could be like, well, I don't have a lawyer. I can't afford a lawyer. And so I'm just trying to navigate this very complex situation. And so they're just filing multiple things or filing in multiple court locations. And so it can be hard to detect, is this abuse or is this someone who's just genuinely unsure and don't know how to proceed in a very complicated system? And like, which one is it?
Right.
Um,
Yeah, and the courts are kind of forced into having to believe people
mm,
on their face. If they say, like, on the face value, like if they say, I'm not sure where I was supposed to file this and I just happen to be closer to this jurisdiction or whatever, the courts don't have a good reason to question that. And that's where that, like, they're legitimate legal processes, but that malicious um, approach can't be detected.
yeah.
Yeah, it's
Well,
normally the survivor
especially.
that,
Well, I was just
yeah.
gonna say, especially in family law, because so many people are unrepresented. So obviously, we're not saying
Right, right.
everyone who's unrepresented has a malicious intent, but then, where again, how do you detect it?
Yeah, absolutely. Yeah.
But there is a case where the
Yes.
court did find, that the perpetrator was choosing to be unrepresented or self-represent in court, even though they had a lot of financial resources to hire a lawyer. His
Right.
income was over 600,000 per year, so he definitely had the financial capability to hire a lawyer.
Yeah.
But also, in fact, he actually told someone that he wanted to represent himself because it allowed him to keep going until the other side ran out of money and therefore could not
Right.
continue the case. And so
Right.
that's where the malicious intent that we've talked about in previous
Absolutely.
episode comes in. He's using the knowledge that, oh, if I keep going and I can continue going, the other side is just going to run out of money soon and not be able to continue with the process.
Yeah, and we see this in many cases where even the abusive party who has the majority of the money or makes more money and more financial resources, they will hire a lawyer. They still have this mentality quite often that I'll keep going until I'm bankrupt before I pay, my ex any money. It's a bit less common for someone to go as far as representing themselves, but it's not unheard of. There are definitely multiple situations that we've heard about where the person with more financial resources, who is the abusive party, will self-rep
Mhm.
on purpose for strategic reasons. Yeah,
Hmm. I mean, there's reasons why, like for example, in a trial, you can cross-examine the other
right.
party,
Huge
or
intimidation. Yeah,
yeah, not using up your financial resources so that you can continue to make various applications in court, even if they're fruitless or perhaps vexatious. And in this scenario, the court did recognize that the litigation that was fueling by the perpetrator was very expensive for the survivor, and that it amounted to intimidation and harassment. There was, of course, other various forms of abuse that came up. One, he threatened to close down his practice as being a dentist. Um, he was using the litigation to create more financial hardship, failing to provide financial support. So all these various things, coupled with, we talked about financial abuse in our previous episode, amounted to what the court identified as intimidation and harassment. And eventually,
right.
the father in this situation was found to be a vexatious litigant in courts, which is actually quite a rare finding for the courts to identify this, because it goes back to what we're saying. Like, these court applications may be legitimate. The court is supposed to be open to everyone. So to bar someone from going to court to make an application is quite a high bar.
Right. Yeah, I was going to ask you to explain a bit further what that label of vexatious litigant means. And it's a high bar to reach, you're right, for a very good reason. But sometimes it's insane what someone can get away with before they are labeled this way. So if there is an abusive party who is filing all these applications, and they're just frivolous applications. They're only meant to slow down the process and confuse the other side. And then the courts decide that they're going to label them as vexatious. What does that mean?
It could mean like various things. The court, when you have that label, the court could put like certain things in place that prevent the party from filing further applications, or they have
Right.
to meet certain expectations that the court has, or certain procedures that the court has in order to continue with their application. The difficulty with this type of, you know, recognition is that it, like, A, there needs to be a pattern, and it usually needs to
Right.
happen over a period of time. And so oftentimes, again, it's on the survivor to recognize this, to bring it up to court, to make an application, and have the court recognize the that this behavior is inappropriate in order to be
Right.
identified as vexatious. And
Right.
so the system again is putting the burden on the person who's facing the harm to prevent it from happening again.
Right, right. And in this particular case, the abusive party, he was self-represented, and then the survivor, did she have a lawyer?
You know what? You're asking a very good question. I can't remember.
Oh,
I'd
yeah,
have
I
to
was
look back
looking
at my
at.
notes.
Yeah, no, that's okay. I was only asking because I was interested in whether that was the route that the survivor was able to go to get to that vexatious litigant threshold and bring it to the attention of the courts. Because also, you would know better whether courts will voluntarily just label someone as vexatious. I mean, I presume that someone, if both sides were self-represented, I presume that a survivor could highlight this is craziness. Look at all of the stuff he's doing. I'm telling you, court, he's just doing this to exhaust me and to wear me down and to deplete my financial resources or whatever. And I'm sure that the courts can translate that. But yeah, it's too bad that it's a rare finding, but I know it needs to be balanced with the fact that everyone needs to have the freedom to apply for what they want so that the courts can then make the judgment of whether it's appropriate or whether there's evidence to support it. Yeah.
Yeah, I
Oh,
I
it's
think
tricky.
also I think the way that the family law system is set up, um, it makes it challenging to identify,
Yeah. Yeah.
especially if the survivor doesn't have legal representation to make those arguments and present the pattern to court.
Well,
Because
exactly. Yeah. Yeah.
that you're going to court maybe for multiple court appearances, but you could get a different person, a different judge, decision maker every single time.
Right.
And to this person, it could be, and you that could be the first time that they're hearing your case. And so they don't know a lot of the times what has happened before, what is the history of this case, and whether
Hmm.
those applications were frivolous. And so maybe it's just the one that's appearing before them, that application seems like out of whack, but they don't, the
Right.
judge doesn't know that all those other applications were out of whack
Yeah.
as well.
Right.
And
Yeah.
so it
Yeah.
takes like the judge to, in order for them to see the pattern, it does need to
Hmm.
A, either be presented to them, or B, they're the same judge hearing this same like issues, seeing the same
Right.
parties over a period of time in order to identify these patterns.
Yeah. Well, and we've heard survivors becoming very frustrated when it's not the same judge every time they go back for an appearance because, yeah, you're right. Then the judge is less likely to be able to detect this pattern of bad behavior. But the courts, again, going back to the neutrality and the assumption that everyone is there in good faith, the courts wouldn't recognize different judges, um, presiding as a problem because they're not assuming or the systems aren't set up to detect that they could be exploited. So,
Mm-hmm.
yeah, we're kind of going around in
Mm-hmm.
circles with it, right?
I think some judges have identified this being an issue, especially
Right.
perhaps for unrepresented litigants, and not because one party or the other is vexatious, but they've identified, oh, these people have come to court like numerous times, and so maybe I should continue hearing this up to a certain point. And so in legal terms, they call what is called being seized of the matter. And so some
Right.
judges have said that they would be seized, or they would be the same judge
Yeah.
hearing it the next time the parties come. And that there might be good things, there might be bad things for it, but at least for the parties who are concerned about different judges hearing different issues, or repeating themselves, right? Like parties
Yeah.
needing
Having
to
to just go over it all
introduce,
again.
yeah,
Yeah.
they might it might be helpful for them to skip that part and just go
Right.
right into the crux of why they're there that day.
Right.
Um, but yeah,
Well,
we
without,
talked
yeah.
about this being difficult to identify for all those
Hmm.
reasons.
Yeah. Well, and I don't want to stray too far from it. We'll come back to the case and just generally, but I do really like the example of a judge recognizing that there is some validity and some value in maintaining continuity so that they're the ones hearing, hearing after hearing and being consistent about being the decision maker, because that's a person who's recognizing a pattern in a system that does have remedies for that. The C's system, it does work that way, but it takes the people in the system to use the resources that we have. And so I think that that's as much as we want to make systemic change, because there are definitely some inherent biases in systems and that kind of thing. I don't want to underestimate the value of people working in the system doing that kind of
Mhm.
adjusting. It can make a really big difference.
Mhm. And at the end of the day, you know, for family law, and especially for parenting issues, we're talking about the best interests of the children, right? And
Right.
so
Yes.
coming back to that foundation of what is in the best interest of the child, especially if the parties aren't able, like are on opposite ends of the spectrum of what they can agree on, and
Right.
having to continuously present to the court what they want, and especially if there's been a long history of litigation. um
Right.
I think that could be very very much one of the reasons why we may want one decision maker throughout, maybe not like at until the very end, because there are certain legal procedures in place for a reason. But
Right.
in
Right.
the
Right.
we know that it takes a long time to finalize family law matters, perhaps 2 or more years, and in those 2 years children don't stop growing. They still
Yeah.
need to
Yeah.
There's still things that need to be decided about children. So,
Right.
um,
Yeah, it's good to always come back to this central premise of best interest of the child. Absolutely.
mhm, mhm. But yes, we've made
Yep.
tangents again, going back to
Yes.
litigation
Yes. So
abuse.
yes, exactly. Was there anything else on that case that you were outlining that it is encouraging that the vexatious litigant label is used sometimes, that the courts recognized and called it intimidation and harassment? This is all very positive and encouraging. Is there anything else on that case?
I just want to note that, like, I think it's very interesting to use language like fueling litigation that appeared.
Mm,
Um, it it made me kind of, um how should I say, like, aha, like finally someone
right,
like is able to label
right.
this.
Yes,
Yeah, and that recognition. Hmm.
right. Yeah, that's great. So, in our previous episode, we were talking about financial abuse and that it is maybe a
Mm,
little easier to identify as opposed to as we get into litigation abuse, which often has the underpinnings of finances and a
yeah.
financial disparity. It's harder to detect. And so just even talking about like delay tactics to wear
Mm-hmm.
down a victim's financial resources. That's where, the financial abuse and the litigation abuse are definitely overlapping. It's also delay tactics also wear down someone's energy and their resolve to keep, following through on legal processes. It also coming back to the best interests of the child when a parent, normally it's the mom who's at the financial disadvantage when she's looking at her children going, why am I even doing this, when she can see that appearing in court and pursuing legal processes is going to be hard on her kids as well. There are a lot of reasons why litigation abuse is effective in wearing someone down. Um, yeah, some examples, Vicky, of tactics.
Yeah. Yeah, we talked about, making multiple court applications. There's some that don't involve the court. So we have seen people, constantly changing lawyers because every time a new lawyer takes
Right,
on the file, they need to get caught up on the file. And it's proper to give the lawyer some time to maintain and catch up on the file. Or stalling to find lawyers, like,
right, yes,
or like saying I'm trying to get legal advice. I'm waiting to have a lawyer take on my file. So those are some that don't need to be in court in
right,
before a judge. Other ones are such as like constantly emailing and constantly calling the survivor's lawyer. So that's a tactic for financial abuse as well. Draining the
right,
resources. If the person has a legal aid contract, then that's like draining their legal aid hours because legal aid only provides a set number of hours for the lawyer to work on a file. So these are actually quite common tactics
yeah,
that I
yeah,
am aware of, that can happen to a survivor. And the court can't do anything about this, because the other side is entitled to change lawyers. The other side is entitled to legal representation. They should be talking to the survivor's lawyer in hopes to resolve things. Um, but at the end of the day, it's all wearing down on the survivor's resources, whether it's financial resources or the legal aid resources.
right. Yeah. Just thinking about some other examples of litigation abuse and using the court system and processes as a means of control. Parenting time is another one that,
Mm.
and it's a really, really heartbreaking area when an abusive party or an abusive parent is using parenting time as a means of control, because they end up, the term that lots of people use, using the children as pawns, basically.
Hmm.
And so
Yeah.
just leaving children in the middle and having kids impacted by this struggle for control. A father showing up late for parenting time and requiring mom to wait with the children, for 20 or 30 minutes. It has a really big negative impact on the kids and also on the mom, who's like, is he going to show
Hmm.
up at all? And is he going to return the kids on the other end? And it just, causes all this spiraling about,
Hmm.
yeah, and it puts her kind of at a disadvantage again. But
Yeah.
even things like the parental responsibilities and choosing how, or what extracurricular activities kids are going to be involved in. Like if dad registers kids in baseball and soccer, for example, and he attends because he either is coaching or he's friends with the coach or he just is on the sidelines and can just go and watch. If he's doing that during mom's parenting time, then he's monopolizing how she is able or not able to spend time with kids. And he's interfering with her parenting time in that way, right? And on the surface, again, going back to like litigation abuse being so hard to detect, on the surface, there is nothing wrong with a parent registering their kids for soccer. This is such a normal thing that so many families do. even in a case that we had supported a client where the dad had registered kids in a really highly competitive, high commitment ski team, it meant that not only did he not have as much time with his kids, but it monopolized the time when
Mm.
she had the kids. And it was really expensive. So again, it's going back to the financial abuse part. We're controlling money, controlling how money gets spent. And on its surface, if you're in a ski town, for example, and your kids are in competitive skiing, that's not weird. It's not going to raise a red flag. But the malicious intent could very well be under that. And yeah, when it gets into a courtroom and the parties are talking about parenting time, this is a very difficult thing to prove or even bring up. How do you bring this stuff up?
Yeah, I think it's like going back to the challenges of identifying it, because we're just, the other party could just be like, well, I want my child to be experienced in all these extracurricular activities. They enjoy
Yeah,
it. It's good for
totally.
them. It rounds them out as a person. Like, what child
Right.
doesn't want to be in extracurricular activities? And it's just like, okay, you look at, there's only 7 days in a week, and if each day the child is registered in something and the father is at those activities every day, then
Yeah.
that does impinge on, mom's parenting time. Um, so that's one end of the spectrum where dad is wanting all the time with the children, and then you've got the other end of the spectrum, which you've identified, where father is showing up late or doesn't show up at all.
Right.
And so in some ways, the survivor was like, well, that's great, like, less impact of, financial or family violence onto the children. But then there's
Hmm.
situations where, like, the child was really upset because dad didn't show up, and now I
Yeah.
have to be the person to comfort the child because dad
Right.
didn't do what he was supposed to be doing.
Yeah, exactly. And it is a manipulation of court orders and court processes. When things have been
Mm-hmm.
decided in a courtroom about parenting time, then the expectation is that everyone is going to follow those parameters. And it's important to do that. And so when an abusive party decides not to and is malicious about it, then yeah, that's litigation abuse, right? They
Yeah,
are using and twisting the court systems and court orders to their
yeah.
advantage as a means of control. Yeah.
Or finding ways to manipulate the court order, or finding loopholes because the court
Right.
orders
Finding
are not,
loopholes.
yeah, are not very
Right.
clear, right? They're
Yeah.
not clear about what the parties are doing. And so when you've got someone who's more controlling or abusive, they'll find those wiggle rooms, the
Right.
vagueness in words, to manipulate it to their choosing and to control
Right.
the other side.
Oof. Yeah. Okay. Well, I guess the bottom line is that perpetrators of violence are going to continue to find new ways to maintain that control and keep that power and balance in place. And sometimes post separation, that behavior keeps going through the court system. But yeah, as you've said before, the underlying theme is always the same. It's always about control, right? And then
Hmm.
specifically with litigation abuse, I think it's often about exhausting the other party from furthering their legal claims and stopping them from finding resolution, which oftentimes is the goal of the survivor.
Yeah.
Yeah. Okay, so next time, I feel like it's time to wrap up now. I can't believe it already, but we are going to take a little bit of, can I say a palate cleanser? But we're going to switch gears a little bit. That next time we're going to talk to Natalie Long, one of our colleagues, about trends in family law over the past few decades, highlighting specifically how family violence was treated under the old legislation, which was prior to the Family Law Act, which came into effect in 2013. So that's going to be a super interesting conversation. And I think it will tie together a lot of the things that we've talked about in these first 8 episodes.
Yeah, I think I really want to hear from Natalie is, Family Law Act has identified family violence, and, has that really changed anything since this legislated definition of family violence. So we'll hear more from Natalie next time. And thanks again to listening for listening to our episode number 8 of You Can't Say That in Court. And we'll see you in a couple of weeks. Bye for now.
Sounds great. See you then. Everything that we have said today is not legal advice. If you or someone you know needs legal advice, please consult with a lawyer. We want to acknowledge that this podcast would not be possible without the generous contribution by Women and Gender Equality Canada, Femmes et Égalité des Genres Canada.